Tonight, a heated debate over national security and immigration policy is once again taking center stage in Washington as lawmakers spar over screening procedures for foreign nationals entering the United States. The focus of the discussion, whether current visa and immigration systems adequately protect the homeland, and whether reforms are urgently needed in light of recent security concerns. Supporters of stricter immigration enforcement argue that the American people made their priorities clear at the ballot box, pointing to the more than 77 million Americans who voted in favor of stronger border security policies. They say securing the homeland requires more than just finishing the southern border wall, more than funding customs and border protection, and more than supporting deportation operations. According to these lawmakers, it requires a fundamental restructuring of visa programs that they claim have been exploited to bypass or undermine federal immigration law. The argument echoes the post-9/11 era, when Americans were told that fighting extremist threats abroad would prevent attacks at home. For years, U.S. troops were deployed in Afghanistan and Iraq under the premise that confronting terrorism overseas would stop it from reaching American soil. Now, critics of current immigration policies claim that failures in vetting and enforcement have allowed potential threats to cross into the homeland directly. They point to statistics indicating that 382 individuals encountered at the southern border between 2001 and 2023 were matches on the federal terror watch list. Of those, 99 were reportedly released into the United States over that same period. For opponents of current immigration practices, those numbers represent what they call an unacceptable risk. In a particularly charged moment during the hearing, lawmakers referenced a recent attack in Boulder, Colorado, in which an Egyptian national allegedly used a homemade flamethrower and Molotov cocktails to target pro-Israel demonstrators advocating for the release of hostages. According to testimony, the suspect had entered the United States in 2022 on a tourist visa and later received work authorization in 2023. Critics argue this case illustrates vulnerabilities in the system, especially when individuals are granted extended status or work permits after initial entry. They also raise concerns about social media content allegedly posted by the suspect prior to arrival, questioning whether more thorough screening could have detected warning signs. At the center of the exchange was a policy expert invited to testify before the committee. When asked what she would change if given unlimited authority to prevent tragedies like the one in Boulder, she acknowledged a fundamental challenge. No system can read minds or perfectly predict intent. However, she emphasized that one of the most impactful reforms would be mandatory in-person interviews for non-immigrant visa applicants, as well as for those applying for green cards and immigrant visas. In her view, personal contact provides immigration officers with critical context that paperwork and digital forms cannot capture. Face-to-face interviews allow trained officials to observe behavior, ask follow-up questions, clarify inconsistencies, and better evaluate credibility. The exchange intensified when a lawmaker pressed her to repeat her statement for clarity. We should have personal contact with every single visa holder, every single individual that wants to enter this country. Am I right or wrong? The lawmaker asked. The witness responded carefully, noting that at a minimum, first-time applicants should undergo direct personal interviews. While acknowledging that renewals for low-risk individuals with established travel histories might not require the same level of scrutiny, she stood by the principle that initial screening should involve direct engagement. The broader debate now unfolding centers on how far such reforms should go. Supporters of mandatory interviews argue that in an age of digital applications and automated processing, the human element has been diminished. They say restoring in-person vetting would strengthen accountability and reduce the likelihood that high-risk individuals slip through bureaucratic gaps. They contend that while no system can guarantee perfect security, adding additional layers of review could deter bad actors and identify red flags before entry is granted. Opponents, however, caution that sweeping mandates could overwhelm already strained consular systems abroad. U.S. embassies and consulates process millions of visa applications each year. Requiring in-person interviews for every category of visa applicant could dramatically slow processing times, increase costs, and create diplomatic friction. Critics also argue that the overwhelming majority of visa holders comply with U.S. laws and contribute positively to the economy, education system, and workforce. They warn against policies that treat all applicants as potential threats rather than distinguishing between low-risk travelers and those who require heightened scrutiny. The conversation also touches on broader immigration reform proposals, including enhanced data sharing between agencies, expanded use of biometric technology, stronger cooperation with international partners, and clearer standards for granting work authorization. Some lawmakers advocate revisiting humanitarian parole programs and asylum processing systems, claiming loopholes have been exploited. Others emphasize the importance of balancing security with America's long-standing role as a nation of immigrants. At the heart of the issue is a philosophical divide: how to reconcile national security with openness. Supporters of stricter reforms argue that sovereignty and safety must come first, insisting that even a small number of high-risk admissions justifies significant policy changes. They view the terror watch list encounters as evidence that threats are real and persistent. On the other side, immigration advocates stress proportionality. They note that terror watch list matches at the border represent a tiny fraction of overall entries and emphasize that law enforcement has successfully disrupted numerous plots through existing mechanisms. The Boulder case, invoked repeatedly during the hearing, has become a flashpoint in this larger debate. Lawmakers critical of current policy describe it as a preventable tragedy that exposes systemic flaws. They question how someone allegedly expressing extremist sympathies online was able to obtain a visa and later work authorization. Others caution against drawing sweeping conclusions from a single incident, urging policymakers to rely on comprehensive data rather than anecdotal cases. As the hearing concluded, one message was clear: immigration policy will remain a defining issue in upcoming legislative battles and election campaigns. Calls for mandatory in-person interviews, stricter screening, and visa program reforms are likely to gain traction among lawmakers who argue that the status quo is insufficient. Whether such proposals advance will depend on negotiations across party lines and the broader national mood regarding border security. For now, the testimony has reignited a familiar but deeply consequential conversation: how to protect the homeland while preserving the values of opportunity, fairness, and lawful migration that have long defined the United States. As policymakers weigh reforms, the stakes remain high. National security experts agree on one point: threats evolve, and so must the systems designed to counter them. The question before Congress is not whether screening matters, but how to implement it effectively, efficiently, and constitutionally in a rapidly changing world. The hearing took a sharper turn as lawmakers continued debating the role of interviews and enforcement in the visa process. One member reiterated the position that nearly every new visa applicant, with very few exceptions, should be required to undergo a personal interview before entering the United States. The argument, delivered forcefully, framed the issue as one of sovereignty and democratic mandate. Supporters pointed again to the 77 million Americans who voted for President Donald Trump, asserting that current enforcement actions reflect exactly what those voters demanded. According to that view, the criticism coming from the left amounts to what was described as faux outrage, ignoring what proponents call years of damage caused by weak border enforcement and insufficient screening. The lawmaker emphasized that enforcing immigration law is not xenophobia, but rather the fundamental responsibility of any sovereign nation. Drawing on personal military experience and deployments overseas, the member argued that no other country in the world allows mass illegal entry without strict consequences. The example of being stationed in Saudi Arabia was cited, noting that even entering Saudi airspace requires strict documentation such as diplomatic clearance.
The broader point? Most nations enforce rigid entry requirements, and the United States should be no different. From this perspective, requiring in-person interviews and strong vetting standards is not radical but standard global practice. We are now acting and behaving in a way that enforces the law, the lawmaker concluded, before yielding time back to the chair. Moments later, the floor shifted to the gentlewoman from Texas, Jasmine Crockett, who offered a starkly different interpretation of both the hearing's tone and its substance. Crockett began by addressing what she described as repeated accusations that Democrats want criminals roaming freely or oppose accountability for those who violate immigration laws. She rejected that framing outright. Instead, she argued that the real issue lies in how enforcement actions are being carried out, particularly in cases involving individuals who are attempting to comply with the system. Crockett pointed to reports of individuals being detained while attending scheduled immigration appointments, people, she said, who were actively engaging with the legal process. According to her remarks, there have been instances where individuals presenting themselves for hearings or required check-ins were arrested on site. She referenced a recent mayoral candidate who was reportedly detained after escorting migrants to their appointments, framing it as evidence that enforcement tactics may not align with stated policy goals. She further noted that even religious institutions, including statements attributed to the Pope, had raised concerns about the need to provide escorts for migrants attending immigration proceedings out of fear they might be detained while complying with legal requirements. For Crockett, the disconnect between rhetoric and reality was central. She argued that while supporters of stricter policies claim they simply want people to show up and follow procedures, the enforcement actions described undermine trust in the process. If individuals fear arrest while attending lawful appointments, she suggested, it creates confusion and discourages compliance. The actions don't match up, she implied, questioning whether the implementation aligns with the stated objective of restoring order. Crockett also criticized what she described as cherry-picking isolated criminal incidents during discussions meant to focus on visa policy. She acknowledged that crimes committed by non-citizens are serious, but warned against using singular cases to characterize entire populations. According to her argument, labeling broad groups of immigrants as potential criminals solely based on nationality or origin crosses into dangerous territory. When you start to decide that just because somebody came from another country, they are automatically some kind of criminal, she said in substance, that does sound kind of xenophobic. She emphasized that the overwhelming majority of migrants seek opportunity, stability, and safety, not harm. Turning directly to the integrity of the visa process, Crockett delivered some of her strongest remarks. She argued that restoring integrity does not mean detaining lawful visa holders without transparency. It does not mean revoking visas arbitrarily, nor does it mean punishing individuals for speech that is protected under the Constitution. She referenced concerns that social media posts critical of President Trump or the administration have led to visa scrutiny or revocations. We have a thing called free speech in this country, she reminded the room, underscoring that constitutional protections apply broadly and are foundational to American democracy. The exchange underscored a deep philosophical divide. On one side, advocates for stricter enforcement frame their position as a defense of sovereignty, rule of law, and public safety. They argue that in-person interviews, heightened scrutiny, and decisive action reflect the will of voters and the standard practices of nations around the globe. On the other side, critics warn that aggressive tactics risk undermining civil liberties, eroding trust in legal processes, and unfairly targeting communities based on fear-driven narratives. Beyond the specific policy proposals, the debate revealed two contrasting visions of national security. One prioritizes maximum precaution, arguing that even a small number of dangerous individuals slipping through the system justifies broad structural reforms. The other emphasizes proportionality and constitutional safeguards, cautioning that measures taken in the name of security must not compromise core democratic values. As the hearing continued, it became clear that immigration remains one of the most polarizing issues in American politics. The question is not simply whether visas should be reformed, but how and at what cost to civil liberties, administrative capacity, and international relationships. Lawmakers on both sides claim to seek integrity and safety, yet they differ sharply on the means of achieving those goals. With presidential politics looming in the background and immigration consistently ranking among top voter concerns, debates like this are unlikely to fade. Whether mandatory interviews for nearly all applicants become standard practice, whether enforcement tactics are adjusted, and whether visa revocation policies face new scrutiny will depend on negotiations ahead. For now, the hearing stands as a vivid reminder that the balance between security and freedom remains one of the most challenging questions facing the nation, and one that Congress shows no sign of resolving quietly.
The hearing intensified once again as Representative Jasmine Crockett shifted the focus from border enforcement to what she described as inconsistencies in how visa integrity is applied. If lawmakers were truly concerned about fairness and standards in the immigration system, she argued, then scrutiny should be consistent across the board, including cases involving the president's own family. Crockett raised questions about First Lady Melania Trump and her EB-1 visa, a category often informally referred to as the Einstein visa. The EB-1 is reserved for individuals who demonstrate extraordinary ability in their field, typically evidenced through sustained national or international acclaim. Recipients often include Nobel Prize winners, Pulitzer Prize recipients, Olympic medalists, or individuals with documented and widely recognized achievements in science, arts, education, business, or athletics. Crockett argued that the public deserves clarity about how those standards are applied. She questioned whether the criteria for extraordinary ability had been met in this particular case and suggested that if Republicans are demanding strict scrutiny for visa applicants broadly, they should be equally transparent when discussing high-profile approvals. It doesn't take an Einstein to see that the math isn't mathing, she remarked pointedly, underscoring what she views as selective outrage when it comes to immigration enforcement. From there, Crockett widened her criticism to include broader Republican immigration proposals, including travel bans and visa restrictions that she argued could harm national interests. She contended that sweeping visa revocations and tightened entry policies risk undermining higher education institutions, local economies, and national security itself. Specifically, she highlighted J and M visas, categories often used by exchange visitors, students, and vocational trainees. These visa programs, she argued, are not security liabilities, but economic and intellectual assets. J visas, which facilitate educational and cultural exchange, bring researchers, medical residents, scholars, and skilled professionals to American universities and hospitals. M visas allow individuals to pursue technical and vocational training. Crockett asked a witness whether individuals on J or M visas typically strengthen or weaken the American economy. The witness responded that they generally improve it, even offering a personal example about how a J visa participant provided childcare support that allowed his family to maintain a dual-income household. In a lighter moment, the witness also joked about Melania Trump, drawing laughter in the room before returning to the broader economic point. From there, Crockett widened her criticism to include broader Republican immigration proposals, including travel bans and visa restrictions that she argued could harm national interests. She contended that sweeping visa revocations and tightened entry policies risk undermining higher education institutions, local economies, and national security itself. Specifically, she highlighted J and M visas, categories often used by exchange visitors, students, and vocational trainees. These visa programs, she argued, are not security liabilities, but economic and intellectual assets. J visas, which facilitate educational and cultural exchange, bring researchers, medical residents, scholars, and skilled professionals to American universities and hospitals. M visas allow individuals to pursue technical and vocational training.
Crockett asked a witness whether individuals on J or M visas typically strengthen or weaken the American economy. The witness responded that they generally improve it, even offering a personal example about how a J visa participant provided childcare support that allowed his family to maintain a dual-income household. In a lighter moment, the witness also joked about Melania Trump, drawing laughter in the room before returning to the broader economic point. Crockett then cited economic estimates indicating that J visa holders contribute tens of billions of dollars annually to the U.S. economy and support hundreds of thousands of jobs. She argued that these programs attract the innovators, educators, medical providers, and researchers who help sustain American competitiveness. Turning to healthcare, Crockett warned that stricter visa restrictions could worsen existing doctor shortages. Many hospitals, particularly in rural and underserved communities, rely on foreign-trained physicians completing residency programs in the United States. She argued that visa disruptions could delay or block these physicians from serving communities that already face limited access to care. In her words, fewer doctors ultimately means fewer people receiving needed treatment. She also connected immigration policy to Medicaid, noting that millions of Americans rely on long-term care and caregiver services funded through the program. A significant percentage of caregivers and home health aides are immigrants. If visa pathways narrow and immigration slows dramatically, she suggested, workforce shortages in elder care and disability services could deepen, especially in states that already struggle to meet demand. Crockett framed the issue as one of practical consequence rather than partisan politics. If lawmakers claim to defend American families, she argued, then they must account for the economic and healthcare roles immigrants play in those families' lives. Finally, she turned to U visas, a specialized category granted to victims of certain serious crimes who assist law enforcement in investigations or prosecutions. U visas are designed to encourage cooperation from individuals who might otherwise fear reporting crimes due to immigration status. Crockett emphasized that recipients of U visas are often survivors of violent offenses such as trafficking, assault, or kidnapping. By working with law enforcement, they help strengthen public safety for entire communities. For Crockett, the existence of U visas directly challenges the claim that visas inherently weaken security. In her view, certain visa programs actively enhance it by enabling victims to come forward and aid prosecutions. These individuals, she argued, risk personal exposure and vulnerability to support broader justice efforts. As she concluded her remarks and yielded back her time, the ideological divide in the room was unmistakable. On one side, a vision of immigration reform rooted in maximum enforcement, expanded interviews, tightened scrutiny, and aggressive removals. On the other, a defense of visa programs as economic engines, humanitarian safeguards, and security tools in their own right. The exchange reflected not just a disagreement over policy details, but over the definition of integrity itself. For some lawmakers, integrity means strict gatekeeping and zero tolerance for risk. For others, it means consistency, constitutional protections, and recognition of the benefits immigrants bring to American society. With immigration policy once again dominating national debate, hearings like this serve as a preview of legislative battles to come. Visa categories from EB1 to J, M, and U are no longer obscure bureaucratic classifications. They have become symbols in a larger struggle over how the United States defines security, fairness, and opportunity in a rapidly changing world.